related legislation. There has also been federal legislation introduced, but it hasn't yet progressed. We will focus on New York. However, I will provide background on recent laws in California, Delaware, Vermont, and Illinois, as well as long-standing existing laws in Connecticut and Maine. Out of the 50 states, this handful of states really are some of the few states that have actually enacted posting requirements for sexual harassment and training requirements. Turning to the bias and underrepresentation of women, as of January 2018, women had held just 4.8% of CEO positions in S&P 500 companies, and women made up 44.7% of the total employees of these companies. Only 26.5% of the senior level managers and executives, and 36.9% of first level and mid-level managers, and just 11% of top earners at these companies. So you can see that women are facing an uphill battle in the workplace. Also, women occupy just 21.2% of board seats in S&P 500 companies. Sexual harassment, bias, and sexual discrimination may be a factor in these statistics. Sexual harassment and discrimination can cause significant harm to a victim in your company. There can be a direct loss of compensation if a victim in your company is denied advancement within a corporation, or is demoted by your company, is denied salary raises or bonuses, or is forced to resign, or is terminated. Sexual harassment can also impact an individual's physical and mental health, as well as future job prospects, which is of concern to many human resources professionals because it could impact the bottom line if they are sued. A victim of harassment may not be just the employee who's impacted by the sexual offense. Other employees affected by the inappropriate behavior may be witnesses to the inappropriate sexual comments. These individuals may be impacted even if the comments are not directed at them. So let's go to applicable legal standards, which many of you might know already, but we'll do a quick refresher. Federal, state, and local laws all provide protections for employees in your company to be free from sexual harassment in the workplace. At both the federal and the state level, it is illegal for an employee to harass an employer to harass an employee, or knowingly to permit harassment to occur. So you have the relevant statutes for New York really are the federal statute, Title VII of the Human Rights Act, the state statute, the New York State Human Rights Law, and the city statute, the New York City Human Rights Law, and the recent Stop Sexual Harassment Act. So many people ask at a company, what is sexual harassment? Harassment in general is a form of discrimination that consists of words, signs, jokes, pranks, intimidation, physical actions, or violence that is directed at an employee due to any protected characteristic. What's a protected characteristic? This can be age, race, creed, color, national origin, sexual orientation, military status, sex, disability, marital status, domestic violence, victim status, gender identity, and criminal history. So all of these can be protected characteristics. Harassment includes offensive behavior based on these stereotypes about a protected class and behavior that is intended to cause discomfort or humiliation because of a protected characteristic. It also includes an expression of contempt or hatred for a group to which the victim belongs based on the protected characteristic. When this type of conduct is of a sexual nature or regarding an individual employee's sex, the conduct constitutes sexual harassment. Sexual harassment can occur in a variety of circumstances regardless of the sex or position of the harasser. The victim does not have to be the person harassed. Again, it can be anyone affected by the offensive conduct. Sexual orientation harassment pertains to inquiries about practices of any gay, bisexual, transgender, or nonconforming or lesbian employee, or using pejorative language about these individuals, or expressing negative opinions about these individuals, or making jokes about the individuals. That's all types of forms of sexual harassment. Sexual stereotyping occurs when the personality traits or the conduct are considered inappropriate simply because the employee's personality trait or behavior may not conform to other people's ideas or perceptions of how individuals of either sex should act or look. So somebody's saying, well, you're not acting like a woman should look because you're dressing in a different manner. That's inappropriate. Harassing a person because the person does not conform to gender stereotypes as appropriate in looks, speech, personality, or lifestyle can be considered sexual harassment. harassment because someone is performing a job that is usually performed or was performed in the past, mostly by persons of the opposite sex, is also sex discrimination. The law generally does not prohibit offhand comments or isolated incidents that are not very serious. Unlawful harassment occurs when the conduct is so frequent or severe that it creates a hostile work environment or when it results in an adverse employment decision. Unlawful sexual harassment may occur with or without economic injury or discharge to the victim. So what are some examples of improper workplace conduct? Probably most of you understand what types of conduct are inappropriate, but it's important to just do a refresher list. The New York State policy also has a list on its website, which we'll get to later, and I'll identify the website location. But some examples of improper workplace conduct is dissemination of sexually pornographic images to coworkers, playing sexually suggestive music or programming on the computer, sharing vulgar jokes, sexual comments about another coworker's appearance, unwanted sexual advances such as rubbing a coworker's shoulders or attempting to kiss a coworker, making sexual gestures or sounds such as kissing noises or thrusting motions with the pelvis, posting pictures of sexual images on one's desk or work area, leering sexually, so nonverbal cues like looking somebody up and down, licking your lips, whistling, making cat calls, requesting sexual favors, making practical jokes of a sexual nature, even if you think it's joking, if it offends somebody and impacts the worker, it's problematic. Cornering or confining an employee's physical space in a sexual manner, so actually coming up to somebody and putting them in a corner and using your physical strength to corner them in a sexual manner, that's also inappropriate. Improper touching, such as pinching a person's bottom, stroking or rubbing up against somebody. Persistent questions, verbal questions to a coworker about their sexual history or their gender identity or their sexual orientation, or repeatedly asking someone out on a date who's not interested or giving them personal gifts. So if you've asked somebody on a date and they've said no, even if you've gone on a date with them and they later say no, that's all inappropriate conduct. Repeatedly viewing a person up and down in a sexual gray and touching a person's clothing, arm, body hair without their consent, those are all different types of sexual harassment, problematic behavior. I remember doing a training in my firm and walking toward the door after I gave the training, and I had listed examples. And one of my coworkers said to me, he was drinking a bottle of Powerade actually, and as he drank it, a bunch of liquid came on his upper lip, and he had licked his lips. And he said, "Oh my gosh, Kathryn, I didn't mean to do that. That wasn't. I just did the training. That wasn't sexual in nature." I said, "Look, you're fine. It's totally fine. If it's unwelcome, I'll let you know. But this is the sort of thing that people are more conscious of, and it was just right after the training, so." It was sort of a funny incident, but it was not something that was problematic to me. But people are concerned about the way they act with their coworkers now. So the next slide deals with backlash and showing bias and the Him Too movement. I had done a similar type training for the program for Spectrum News, as Randy mentioned. I was on Capitol Tonight about New York State workplace harassment policies coming into effect. I did it back in September when the initial draft of the guidelines had come out, and I was sitting there in my office, and I received an email from my neighbor who said, "Katie, hey, guess what? Kathryn, guess what? Lieutenant Governor Kathy Hochul has tweeted, has put on Facebook your interview with Capitol Tonight, and of course I knew Facebook, but my next question is, what's Twitter? How do I get on Twitter? Showing my age a bit, but I went on, and I actually went on to Facebook actually first, and I started to read about the comments that had been put onto Facebook about the sexual harassment training, about what the governor had said, and it really sort of impacted me because it discussed a lot about the Him Too backlash. If you look at some of the comments, there's a lot of comments that show the concerns of everyday workers out there. One of the comments I thought was particularly enlightening is, "Keep it up, New York. You'll make it so that companies will only hire men. Good job." A comment about sort of how are sexually harassed men feeling? One person says most men are not predators. What about women who sexually harass men? Shouldn't they be treated the same as male sexual harassers? And then there's also, this includes men and women alike, something that defines proof in the light of accusations without basis or merit, and extends MeToo to include men who have been harassed in an equal manner. So there is concern out there about the MeToo movement and about men being treated fairly if they're sexually harassed as well, and also just when a male is accused in a public opinion, how if it hasn't been actually proven how males are suffering if that happens. So there has been a backlash with the Him Too movement. So I guess the next question is, could the Me Too movement negatively impact the women that it seeks to assist? A recent study of the impact of the Me Too movement shows that nearly 45% of male managers have reported that day-to-day interactions with female colleagues makes them quote-unquote uncomfortable. And some of them even avoid participating in work-related activities such as mentoring. This is a 300% increase from reports issued prior to recent media coverage on sexual harassment. In addition, 34% of employees are concerned about the potential for false claims of harassment or a rush to judgment. Some believe also, as I mentioned, that the Me Too movement has negatively impacted the presumption of innocence until proven guilty and has turned the Him Too movement from a rally cry to recognize that men can be victims of sexual harassment into a counter-movement of skepticism toward women who report the harassment. It is well established, however, that false accusations or convictions are far rarer than unreported incidents of sexual harassment or assault, yet many are quick to point out that the falsely accused are victims too. So one potential negative consequence, as we discussed, is when the public believes the accusations of harassment or assault and they're raised in a way to obtain, quote-unquote, 15 minutes of fame. I did put in an example about the MTV catfish situation where there were some videos detailed on YouTube, and MTV had done some due diligence and has suspended the harasser, but the accuser claimed she was never contacted to give a statement. So both of the parties were impacted. The alleged harasser had reported he got shingles and suffered from severe headaches as a result of the stress of being accused of sexual assault, and he did suffer, and the victim also had problems. So while there has been some concern about men falling victim to false accusations during the Me Too movement, evidence suggests that this is not a widespread practice. Per studies reviewed by the Boston Globe, it is estimated that false accusations account for just between 2% and 10% of all accusations made. Some victims also might withdraw their complaints because they do not want to go to court, and some analysts believe that this percentage may be even lower. This is not to say, however, that the Me Too movement has not had potential negative effects for women. According to a survey conducted by The Economist in November 2017, and then in 2018 of September, right after these sexual harassment guidelines in New York State had come out, there was an uptick in the amount of victim-blaming attitudes in our country, including an increase from 29% to 31% of people who believe that women who complain about sexual harassment actually cause more issues than they solve. And there was also a 13% increase, a 13% to 18% increase for persons who believe that false accusations are a bigger problem than attacks that go unreported or unpunished. So recent Me Too headlines may have led some males in the workplace into panicking unnecessarily, which may lead, unfortunately, to further potentially career-harming actions for women, such as male managers delaying business trips or other career opportunities, deciding the way to stay safe is to avoid working alongside women. I know in my interactions outside of my legal practice, just speaking to neighbors and men that I know, before they even know that I'm involved in the whole Me Too movement and this type of law, they'll say, look, if I'm going to work with a woman in the office and meet with them for a supervisor and an employee, I am going to leave my door open, and I'm going to make sure that people are walking around so that I'm not later accused of doing something improper. So it is on male employees' minds. It could be on female employees' minds if they have an issue with a younger male associate. And so a lot of people in the workplace are taking precautions so that they're not alone in situations where they might become vulnerable to some sort of claim against them. Just a note on bias. Bias in the workplace, it's not always readily identifiable. It often goes unspoken, but it's important for employers to be aware of and to combat. When a person isn't treated unfairly because of the person's sex, it's an actual form of discrimination. I mentioned a couple of cases here that you may want to take a look at. The Dukes versus Walmart class action, where there was a strong and uniform corporate culture permitting bias to impact managerial decision-making. The Supreme Court later reversed the certification of the class regarding the plaintiff's inability to allege a single common reason for employment decisions. But there's been a new suit, Forbes versus Walmart stores, where some of the same class members have filed a new suit in November 2017, and that case is in the early stages. There is an NYU professor, Madeline Heilman, who did a study regarding bias and described how in the workplace descriptive stereotypes create problems for women when there is a perceived lack of quote-unquote fit between a woman's attributes and the attributes believed to be required to succeed in traditionally male occupations and organizational positions. So this is inherent bias sometimes in the workplace. Unfortunately, women in many professions, including the law, confront antiquated stereotypes where quote-unquote male-gendered positions, which include top management and executive positions, are believed to necessitate characteristics that coincide with stereotypic conceptions of men, but not with stereotypic conceptions of women. For example, I'm a lawyer, so I look at legal studies about women and advancement in the law. In 2018, a National Association of Women Lawyers survey on the retention and promotion of women in law firms found of the 97 law firms studied in this survey, 93% of the law firms that reported under this survey, the most highly compensated attorneys are male. And of the 10 most highly compensated lawyers, on average, only 1 out of 10 is a woman. And there really is no significant difference in the number of billable hours between the male and female attorneys. So it's not that the female attorneys are billing less, it's just that they're being paid less. So now we're going to go into the legal standards for hostile work environment. Again, we discussed this at the beginning of the program. Actions taken by the harasser must be severe or pervasive enough to alter the conditions of a victim's work environment. But what does this mean? Courts have held that for actionable harassment to exist, a reasonable person must be able to find the work environment hostile or abusive, and the victim must actually perceive it to be so. It's sometimes confusing, sexual harassment, for human resources professionals because there's no bright line test to determine whether an environment is sufficiently hostile or abusive. Points to consider in an investigation is whether the conduct is unwelcome. I mentioned that earlier in the presentation with the licking of the lips and whether or not that was actually a sexually harassing behavior, and whether it's severe and pervasive, if it's just that one incident versus several incidents where the licking of the lips, which seemed innocent, was then followed up with requesting a date or sending me pornographic images or something like that, and whether the conduct unreasonably interferes with the victim's work. And you need to assess the impact on of the harasser's conduct rather than the intent. So it's the impact on the victim. Did the victim feel that it was unwelcome? Have they been experiencing this sort of on a regular basis? Is it severe? And is it interfering with their work? Are they actually becoming impacted by the behavior so that they're unable to complete their work? Are they suffering from stress? Are they going to see a doctor due to the conduct of the harasser? These are all questions that are considered. Courts review the totality of the circumstances. What does this mean? The frequency of the discriminatory conduct, the severity of the conduct, whether the conduct is physically threatening, whether the conduct unreasonably interferes with an employee's work performance. No one factor is required in order to find actionable harassment, and there is no precise formula for use when considering these factors, which again is concerning to a lot of HR professionals. You have to be able to determine what has happened. We'll get into later in the program about the investigation and identifying the facts involved. In very limited cases, the presence of a single severe act is sufficient to establish a claim of hostile work environment harassment For example, the rape of one employer by another, that could be considered a sexual harassment. Another type of quid pro quo harassment, this for that harassment. Another type of harassment is quid pro quo. It's called this for that harassment, sexual harassment. Quid pro quo harassment occurs in a situation where the benefits of an employment position are contingent on an employee being required to provide sexual favors for an employer, a supervisor, or an agent of the employer. So if somebody says, look, if your boss comes to you in the company and says, look, if you perform this sexual act, I will give you a raise, or I will do something for you, and or if you reject that sexual advance and that results in a tangible employment detriment, such as the loss of your job, a loss of a job benefit, a less desirable work shift, or even a negative employment review, that's problematic under the sexual harassment law. An important case is the Minarsky decision for human resource professionals and legal professionals to be aware of. The court, there's the Farragher-Ellis defense. The court in those cases, there's two necessary elements. Once a employee has actually alleged sexual harassment, the employer can assert an affirmative defense that they've exercised reasonable care to prevent and correctly and promptly address any sexually harassing behavior, and that the employee unreasonably failed to take advantage of any preventative or corrective opportunities. Recently, the Third Circuit in the Minarsky versus Susquehanna County decision, and Thomas Yildowski, who was the supervisor who was harassing Minarsky, challenged this defense, affirmative defense of sexual harassment, and this may create difficulty for employers and your companies. So the United States Court of Appeals for the Third Circuit reinstated the sexual harassment claim against the county that Minarsky brought, even though she had never reported the sexual advances by her supervisor, which she had been repeatedly subjected to over a 4-year period. The county argued that they were not liable for the misconduct of the supervisor due to Minarsky's failures to notify them about the supervisor's conduct, the fact that they had a clear sexual harassment policy in place, and they took prompt action against the supervisor. They alleged they took prompt action against the supervisor, Yelowski, when the complaints from others led to that supervisor's termination. Minarsky, for her part, had only notified a friend who told another employee who informed HR of the supervisor's conduct. The case is concerning for HR professionals from the employer's perspective because action was taken once the employer learned of the misconduct, which should have protected them from a claim of sexual harassment. So many employers may ask, if Minarsky knew of the policy and the process for filing a complaint but did not do so, how can the employer be liable for sexual misconduct? So the Third Circuit held that workplace sexual harassment is highly circumstance-specific. If the plaintiff had a subjective belief that by reporting the sexual harassment she would be retaliated against, and a jury could find that her belief was objectively reasonable, then a trial court could find that the second part of the defense may not be proven by the defendant as a matter of law. Multiple employees, here are some of the facts that I read about in the decision that may, if you can, differentiate this from another sexual harassment case where the employer did assert the defense successfully. Multiple employees had experienced unwanted sexual advances from this supervisor, and plaintiff Minarsky was aware of a warning that this supervisor had received that had not deterred his behavior. Minarsky also had argued that she did not report the incidents because the supervisor knew her young child was sick. I believe her child was getting cancer treatments, and she needed her job to pay for the medical bills. Another issue was Minarsky's fear of the supervisor's hostility on a day-to-day basis and his retaliation by having her fired or terminated. The supervisor would often tell her to look busy or else higher-up supervisors with the county would terminate her position. So the employer's response to the reported, the HR takeaway might be that the employer's response to the reported incidents, the rumors even of the actions of the supervisor, which were well known in the office, was reactionary rather than proactive based on the rumors of misconduct. Even though there was a harassment policy in place, waiting for a plaintiff to bring a complaint rather than HR leaders who knew of the misconduct acting proactively to deal with the harasser and the situation that was well known at the office was problematic. So at the end of the presentation, we can always discuss the Minarsky decision. Retaliation, hopefully a lot of you know what this is, and your companies are careful not to do it. It's any action taken by an employer to alter an employer's terms or conditions of employment, such as demotion or sudden work schedule or location change, because that individual engaged in any of the protected activities. It can be any negative action taken by the employer against the employee that could have the impact of discouraging a reasonable worker from making a complaint about harassment or discrimination, or if a worker has participated in an investigation or actively assisted when somebody has made a complaint and then they're punished for that, that's retaliation, and that's problematic. What's not retaliation? A negative employment action is not retaliatory merely because it occurs after the employee engages in a protected activity. So in order to establish a claim of retaliation, an individual must show that the adverse action was motivated by the protected activity. Protected activities include actions taken by employees who oppose discrimination, harassment, or retaliation. And as I mentioned before, an important note is that the law protects not only employees who complain directly of harassment or discrimination, but also employees who participate in an internal investigation by the company of the complaint as a witness. Part of preventing harassment in the workplace is that I think that you have to establish a culture where everybody feels responsible for making sure that it's a safe and ethical environment for all employees. So to stop sexual harassment, management has to know about the harassment. So all of your employees should know. It shouldn't be a secretive question. If somebody harasses, it's everyone's responsibility to report the harassment. So employees must be encouraged to report harassment to a supervisor or manager or other person designated by the employer to receive complaints. It should be outlined in your sexual harassment prevention policy, which we'll get to later, so that you can take action to correct the harassment, and the employer must clearly and uniformly enforce the sexual harassment policy. And the behavior, importantly, sexual harassment doesn't have to be a violation of the law in order to violate a sexual harassment policy. So getting to the sexual harassment prevention guidelines for all New York City and state employers, I'm going to go through them for the city and the state in the event that any of you have offices in New York City as well. And then I will also go through the recent laws in other states such as Delaware and California, which has been very proactive as the epicenter of the MeToo movement. You can imagine they've had a lot of legislation that's recently been enacted into law this year about the sexual harassment prevention guidelines, the policies, and other requirements. Delaware is another state that's recently taken action. And then also Maine and Connecticut, who've actually had training and posting requirements for quite some time, since the early 90s. So let's start with New York State and city requirements. With the MeToo movement, Governor Cuomo and Mayor de Blasio have come out swinging by passing laws directed at fighting sexual harassment throughout New York State. Employers have to be aware that the new sexual harassment laws, at least for the state are applicable to all employers, even those with only one employee. So the state human rights law requires even companies with just one employee to institute these changes. In the city, if you have a part of your offices in the city, beginning on September 6, 2018, companies in New York City were required to replace a poster about anti-sexual harassment facts. So there is a poster. This is a poster. You can get it on the website. It's called the Stop Sexual Harassment Act Fact Sheet. It provides information about the New York City human rights law, what sexual harassment is under the law, a form of gender-based discrimination that's unwelcome verbal or physical behavior based on a person's gender. It provides examples of sexual harassment. It provides a provision regarding retaliation that it's prohibited under the law. And then it has an actual number where you can call the New York City Commission on Human Rights about any instances of sexual harassment. And it also has a provision in here about state and federal government resources. There's also the notice, which is very similar to the fact sheet. So, if you're a city employer, you have to have these. New York State. Yes, the deadline has passed. Companies in New York State are required to have a specific written sexual harassment policy at their companies, and it has to be instituted and applied, and the company is required to deliver the policy to all of its employees. So under the new law, every employer in New York State, your company, if you have more than one employee, even small companies, are now required to establish a sexual harassment prevention policy pursuant to the labor law. And the Department of Labor, in consultation with the New York State Department of Human Rights, has established a model sexual harassment prevention policy for employers to adopt. The website is here. You can Google it. You can Google New York State Sexual Harassment Prevention Policy. There's actually a sample policy on the website that you can access and you can use. So the employers, as an employer, you can adopt a policy similar to the one that New York State has put forth, as long as it meets or exceeds the minimum standards of the model policy. If you don't want to use the exact model policy, you just have to be sure as a company that your policy meets or exceeds the minimum standards of this model policy, which, again, you can find on the New York State Human Rights website. Companies can also consult with an attorney and create their own company policy against sexual harassment if the company's policy is equal to or exceeds the standards set forth in the policy from the New York State that's provided by the New York State agencies. Requirements for the New York State Sexual Harassment policy, again, the minimum standards for sexual harassment prevention. This is actually a form that I pulled off of the New York State website that has all the information that you need regarding your policy at your company to comply with the New York State law. An employer, again, can adopt this type of policy. They can flesh it out as long as it meets or exceeds this standard policy. It's again what we've talked about, providing examples of prohibited conduct, including information concerning federal and state statutory provisions concerning sexual harassment and remedies available to sexual harassment victim. A complaint form, which I'm going to show you in a little bit, about if an employee actually has a complaint, what they do and how you proceed with investigating a complaint. A procedure for the timely and confidential investigation of complaints that ensures due process for all the parties. You have to inform employees of their rights of redress and all available forums for adjudicating sexual harassment, which we will discuss later in the program. Clearly state in the policy that sexual harassment is considered a form of employee misconduct and that sanctions will be enforced against any worker engaging in sexual harassment and against supervisory and managerial personnel who knowingly allow the behavior to continue. So if your supervisors or managers know about the sexual harassment, if they've heard rumors of the sexual harassment and a supervisor behaving inappropriately, they have an affirmative duty to take that to HR, to take that to the legal department and make sure that an investigation is conducted. Last point, can clearly state that retaliation against individuals who complain of the harassment or who testify or assist in any investigation or proceeding involving sexual harassment, that's unlawful to do. Here's a complaint form for sexual harassment. Again, I can access this. You can access this through the New York State Human Rights website. It's a very specific form, a complaint form for reporting sexual harassment. When you receive a complaint of sexual harassment, you must you can actually receive it verbally and fill out the form for the employee, or they can actually fill out this form and provide it to you, either verbal or written. A complaint must be taken seriously, must be investigated. The complainant must fill out the information. You can look on here. I don't know if I'm going to go through the whole form, but it includes their name, their home address, all their information, and then specifics about the complaint, who the complaint is made against, any witnesses to the complaint, and so on. So you can take a look at the complaint form for reporting sexual harassment, and you should have that in place. Additional requirements for the New York State Sexual Harassment Policy. So again, I mentioned this when I read through the actual policy from the website, but companies must advise supervisors and managers in a company that sexual harassment is a form of employee misconduct and sanctions will be enforced against supervisors and managers if there's any issue that comes up where they haven't reported the misconduct. The policy must also, again, include information regarding state and federal laws and a statement that local laws may also be applicable. There's also the employee rights section where they can seek redress, including proper venues, which we discussed, and then also the sexual harassment as a form of misconduct and the definition, retaliation is prohibited. Last point here, a signed acknowledgement of receipt from employees is not required but is recommended. I would do this. I would have an employee, after they receive the policy or a handbook, in fact, any handbook should be signed as well, I would have them sign it so you can prove, if a lawsuit comes up, that you've actually that this employee who is alleging sexual misconduct has actually, or the employee or the supervisor who's actually the harasser, they've actually taken taken a look at the policy. They've signed something saying they looked at the policy in your handbook. That's important. It's not required, but it's important. New York City and state sexual harassment training. So within 1 year of April 1st, 2019, the New York City law applies to employers with 15 or more employees. It's not 1 or more employees, but companies with 15 or more employees are required to provide interactive prevention training for sexual harassment to all employees, part-time, full-time interns, and new hires as soon as possible after their start date. And by October 9th, 2019, so there has been a bit of a reprieve with the New York State sexual harassment training requirements. We had initially, when we looked at the requirements at my firm, it was a pretty tight deadline. So we had done our training. I did the training pretty early on in the fall, but there was an extension of the deadline. So companies now have more time, not of the policy requirement, of the training requirement by New York State, so that if you have not conducted the training yet, you do have more time. Every New York State employer must have, by this date, must have completed sexual harassment prevention training, again, that meets or exceeds the minimum standards under the law, and employees must receive the training annually. Every employer in New York State, as I mentioned, is now required to provide employees with sexual harassment prevention training, and the Department of Labor, in consulting with the Division of Human Rights, has established a model training for employers to use. Again, there's a wealth of resources on the New York State Human Rights website. You can even Google it. I have the website here. It's www.newyork.gov, and there's an actual sexual harassment draft model training policy. Companies need to train individuals who work a portion of their time in New York State, even if they're based in another state. So if your employees work a portion of their time in New York State, they must be trained under the sexual harassment prevention policy training. And as with the sexual harassment policy requirements, the training program can be one of the model programs from the New York State Department of Human Rights or the New York Department of Labor, or it can be an employer's own policy. You can hire a training company to do it, an attorney to do it, as long as it's equal to or exceeds the model training program. Again, the model training program is right here. The training should be interactive, but it may be available online as long as employers are actively viewing the program, clicking through it. So per the requirements of New York State, sexual harassment training must be, as I said, interactive. It must include an explanation of sexual harassment consistent with the guidance issued by the Department of Labor in consultation with the Division of Human Rights, the New York State Division of Human Rights. It must include examples of conduct that would constitute unlawful sexual harassment. It needs to include information concerning federal and state statutory provisions concerning sexual harassment, information regarding an employee's rights of redress and all available forms of adjudicating the complaints, and information addressing conduct by supervisors and any additional responsibilities for such supervisors. So it's similar to the policy, the requirements for the training. If the training is web-based, if your company decides to do a web-based training, there has to be questions at the end of a section, and the employee must select the right answer so you know that the employee is actually viewing the program, is taking the training seriously. Also, if the training is web-based, the employee should have an option to submit a question online and receive an answer immediately or in a timely manner. If it's an in-person or live training, the presenter can ask the employees questions or provide time throughout the presentation to ask questions. Web-based or in-person trainings that provide a feedback survey for employees to turn in after they've completed their training is also important. Cautionary notes for HR members watching this program. Additional recommended measures to be taken by employers. So some things to consider that aren't necessarily required by New York State, but that your company might want to do. Have a policy in your actual handbook regarding inter-office dating and fraternization. If you know two employees are dating, if they're a supervisor and a subordinate, that's problematic because at any time that relationship could turn sour, and then there could be potential for some sort of claim against your company. So inter-office dating policies, it's not the subject of this of this webinar, but is important to consider. Having anti-discrimination policies. I'm sure a lot of you already have this in your handbook, but it's not just harassment you have to be concerned about. It's also anti-discrimination provisions. And also maybe a statement saying that New York State's requirements may not satisfy requirements under federal law, and federal laws might conflict. Companies are not required to train non-employees. However, employers are encouraged to provide the policy and training to anyone providing services in the workplace. If you have somebody who comes in as a temporary employee and is at your company, and you become aware they've committed have acted in an inappropriate way or had some sort of allegation leveled against them regarding sexual harassment, you still, if it's happened on your premises and they work there regularly, I would be concerned about them being able to launch a complaint against your company. So it's, as I said, it's not required. Maybe the temp company that you're contracting with to bring in the temp, maybe they have training. I would check that. Every company should. If they don't, it may be worth actually, if you know an employee coming in is regularly providing services at your company, it may be worth giving them some training under New York State law. It doesn't take long. As I said, as I write here, there's no minimum length of training for the New York State harassment training requirements, but you do have to make sure that your training actually meets all the web-based requirements or in-person live requirements and has the content that's required. But it doesn't need to be a 3-hour training. It has to be substantive, it has to be interactive, and it has to meet the basic requirements. Under the New York State human rights law, companies can face liability where an employer, including agents or supervisors who knew or should have known of the sexual harassment, where they did not report it, and the company failed to take immediate or corrective action, a company could face liability. A note about non-disclosure agreements. I'm sure many of you have had employees who may be leaving your company, and you have provided severance. And as part of a settlement agreement, you are obviously concerned if there's a claim of sexual harassment or sexual discrimination that your company is protected, and that the part of the incentive for providing a settlement agreement and providing severance is that the sexual harassment allegations will not come to light, especially with all the publicity surrounding MeToo. So there's a new requirement in New York. It's actually since July that New York State companies that enter into settlement agreements with employees are not permitted to include a non-disclosure provision, a provision pertaining to sexual harassment that be kept confidential, unless it's the employee's preference that such a provision be included in the agreement, and the preference needs to be memorialized by an agreement signed by all the parties. And there's also another law that's recently come into effect regarding mandatory arbitration. Many times in settlement agreements, there will be a mandatory arbitration provision saying that if a dispute arises under the settlement agreement, that the adjudication will be handled in an arbitration by an arbitrator. So again, arbitration, the arbitration is not typically public. So again, it adds to being able to conceal the facts related to potential misconduct within the workplace. So New York State and other states, this is not just New York State. There are other states that have enacted laws regarding mandatory arbitration. So if it's a concern that you will not actually be required, or the employee will not be required to bring a dispute regarding sexual harassment to arbitration, that's another law that you should be aware of. For the non-disclosure agreement, to memorialize the complainant's preference for a non-disclosure agreement, it's a similar timeline to the Older Workers Benefit Protection Act, which probably a lot of you have encountered in preparing a settlement agreement, where you have to wait 21 days and then 7 days to actually make the agreement effective with an older worker that's over 40 under the Age Discrimination Act. So with a non-disclosure agreement, any such term or condition must be provided to all parties. So the non-disclosure provision regarding sexual harassment has to be provided to the employer and to the employee. And the person who's complained of the sexual harassment has 21 days from the date of the term, of viewing the term, to consider it. If after 21 days the term of the condition is the preference of the person who complained, the preference is then memorialized in an agreement. It's signed by all parties, and then there's that 7-day waiting period. So for a period of 7 days following the execution of an agreement containing the term, that person can actually revoke the agreement, and the agreement will not become effective or enforceable unless that revocation period, that 7-day period, has also expired. So something to be aware of when you're negotiating a settlement agreement with a sexual harassment plaintiff. So as I mentioned before, I want to provide some background in case you have your company has offices in other states. Again, it's a small handful of states in terms of the posting requirements and the training requirements and policy requirements that have actually taken action. And there's some states that have had these laws on the book for quite some time. So you need to be aware of other policies, even the evolution of these policies in light of the MeToo movement, so that you're aware of sort of what's going on in this whole realm of sexual harassment. So California, as I mentioned, is one of the most active states with regard to the MeToo movement and taking the lead to enact legislation to protect victims in California. It was the epicenter of the MeToo movement. If you remember, the MeToo movement started with a social activist back in, I believe it was 2006, Tarana Burke, and the concept was actually brought into the public awareness at that point. But most people understand that it actually, as a social movement, occurred much later with Melissa Milano, the actress, putting hashtag MeToo in response to a social media post. So that was when the concept went viral, but the actual the social activism part of it started quite some time ago. But as I said, with California and Alyssa Milano and a lot of the other actresses in Hollywood taking action in the social media part of this is when the concept really did go viral, and states have been taking action more recently. So on September 30th, 2018, this fall, not too long after when the New York State legislation, when we were discussing that, I was discussing my interview on Capitol Tonight and how it was finalized. It was in the process of being finalized in the fall. The California governor signed into law several bills that serve as a comparator to New York State's anti-harassment laws, and these laws pretend the corresponding evolution of state action in response to the national movement. The laws have become effective now. They became effective on January 1st, 2019, and California is the first state to pass. This is an interesting law, and there's been a lot of challenges to the law, but it's the first state to pass legislation requiring the publicly held companies with a principal office in California have a minimum number of female board members, and I'm not sure of the exact number. I have it, but it starts with one female board director, I think, this year, and then there's an increase depending on the amount of board members that sit on a California company's sit on the California a company in California's board, and they actually increase through the years in order to make sure that there are female directors in company boards in California. It's important because I think the more you have female directors or females in leadership positions at certain companies, it may impact the number of sexual harassment claims that a company might have. There's nothing necessarily proven on that, but it's just it seems to make sense, and I think that's why California passed this law. California law also now provides that any provision in a settlement agreement, we just talked about New York settlement agreements, that prevents the disclosure of factual information relating to certain claims of sexual assault, sexual harassment, or harassment or discrimination based on sex filed in a civil or administrative action is void as a matter of law and public policy. And California law does not prohibit the entry or enforcement of a provision in any agreement that prevents the disclosure of the amount paid in a settlement claim. There's a lot of discussion among plaintiff side attorneys and defense side attorneys are also concerned about the new laws regarding non-disclosure agreements and whether they are advantageous to women who are suing for sexual harassment or attempting to get a settlement for sexual harassment, because a lot of times it may impact an employer's willingness to provide severance to an employee if they feel that the claim is going to be made public anyway. It might impact the ability of a plaintiff to actually obtain something short of a verdict in court. So there is some concern about the non-disclosure provisions, even though, as we discussed earlier, you want to help women who are undergoing these sorts of issues with sexual harassment. The question is whether non-disclosure agreements and having them barred for sexual harassment claims, whether that actually helps the victim or not. So that's a current sort of hot button topic. Employers in California are also now prohibited from requiring that a current employee waive sexual harassment claims by a current employee at your company in California. Whether you cannot now require that your employee waive a sexual harassment claim by requiring the employee to sign a release or claim of the right under the California Fair Employment and Housing Act, or a non-disparagement agreement or other agreement that prohibits an employee's right to disclose information about unlawful acts in the workplace in consideration for an employment benefit, such as a raise, a bonus, or continued employment perk. Recent California legislation also alters the burden of proof necessary to impute liability to an employer by making a single incident of harassing conduct sufficient to create a triable issue of fact and overturning the one free grope rule. So again, more action in California. Getting to sexual harassment training requirements in California, it's modified its sexual harassment training mandates to require that companies now with just 5 or more employees, including temporary or seasonal employees in California, by January 2020 provide at least 2 hours of classroom or interactive training. This is just to supervisory employees. However, there needs to be 1 hour of training to non-supervisory employees within 6 months of the starting date in these positions. California had previously required employers with 50 or more employees, so they've become more strict in the requirements for training. Before it was 50 or more employees, provided 2 hours of sexual harassment prevention training to all supervisory employees within 6 months after training. Now it's a smaller requirement, companies with 5 or more employees, and California now requires training for both supervisory and non-supervisory employees. Delaware is another state that's become active as a result of the MeToo movement. In July, it passed an amendment to the Delaware Code relating to sexual harassment, posting, and training requirements. It went into effect on January 1st. The amendment directed that the Delaware Department of Labor create a fact sheet for employers stating that sexual harassment is illegal, the definition of sexual harassment, and the remedies and complaint process, and how to contact the Delaware Department of Labor, and also the illegality of retaliation. Again, you can see sort of a pattern here. It's very similar to what New York requires in its policy and training. The posting is similar to what New York City requires. So there is a Stop Sexual Harassment Notice, the Delaware Sexual Harassment Notice, which meets each of these requirements and also references the Delaware Discrimination and Employment Act and provides specific examples of sexual harassment. You can see on the Delaware's website, if you have a lot of companies do have are incorporated in Delaware, so this may be important for some of your companies. The Sexual Harassment Notice can be found at the website here, www.dol.delaware.gov. And the Delaware law states that it has to be distributed to new employees at the commencement of employment and to an existing employees by this July. Here's a copy of the Delaware Sexual Harassment Notice. I can find it on the web. You can find it on the web. It's called the Delaware Sexual Harassment Notice. Again, it's very similar, as far as I can tell, to the New York State sexual harassment, the New York City sexual harassment posting notice that I showed you earlier. It has a description of the Delaware Discrimination and Employment Act. It has a description of sexual harassment is, what it is under the law. It requires examples of sexual harassment, a statement regarding retaliation that it's prohibited under the law, and where you report sexual harassment to the Delaware Department of Labor's Office of Anti-Discrimination. So again, very similar to the New York City posting requirement. Delaware also now requires an interactive training process for employers with 50 or more employees to be given to employees within a year of inaction and biannually thereafter. Supervisors must undergo additional training. So in Delaware, if you're a supervisor, in addition to the interactive training for regular employees, you also have to be given training regarding responsibilities to prevent and correct sexual harassment. That's also very important. Vermont has a law which became effective in July 2018, and this is a different type of law. I did a little research into this, and it looks like the Vermont Human Rights Commission or the Attorney General can actually inspect businesses and question those authorized to investigate sexual harassment complaints and examine their policies and procedures, and then they will provide their findings to the employer, identify problems found, and provide resources and aid for further prevention strategies. And if it's deemed necessary, the AG or the Human Rights Commission in Vermont can require the employer to hold annual sexual harassment trainings for a period of up to 3 years. So it's not a blanket requirement. It's based on what they find when they actually investigate these companies. Illinois requires all professions with a continuing education requirement that those professions have to provide at least 1 hour of mandatory sexual harassment training, and positions in Illinois that require continuing education are much like you'd find in any state: medical professions, dentists, optometrists, those types of professions. So again, a more narrow take on sexual harassment training. Maine actually was the first state in the United States to require sexual harassment posting and training requirements to combat sexual harassment in the workplace. So since October 1991, which is quite some time ago, Maine state law required that employers hang a poster in a prominent and accessible location in the workplace detailing that sexual harassment is illegal, what sexual harassment is, the complaint process, and how to contact the Maine Human Rights Commission. It's probably not out of the realm of possibility that New York City may have looked at this posting requirement when they actually came up with the posting requirement for New York City. Maine, like New York City, requires employers with 15 or more employees in the workplace to conduct an education and training program for all new employees within 1 year of commencing employment. The training, again, it's similar to a lot of the training that we've discussed already. It has to discuss the illegality of sexual harassment, the definition of sexual harassment under state and federal laws and federal regulations, a description of sexual harassment, examples of sexual harassment, provide an internal complaint process that's available to an employee, the legal recourse and complaint process available through the Maine Human Rights Commission, and directions on how to contact the Commission and protection against retaliation. So again, very similar to what we've seen in other states. Supervisory employees in Maine must have additional training within 1 year of their new position that includes their responsibilities as managers to prevent and take action against sexual harassment. Employers who do not conduct these trainings for their employees or who do not follow posting requirements actually in Maine face monetary fines. So again, some states will require supervisors to have an additional training. I would recommend it, even in New York, to have something in the training. I think it is required, maybe not as a separate training, but in the actual training that supervisors could be determined to be liable if they do not report sexual harassment and they know about sexual harassment. So whether or not it's a separate training, I do think that supervisors should be trained on their obligations, even if you need to separately from the regular training. Per the Maine statutes, employers have to hang the poster. Again, the requirements are similar to other states: illegality of sexual harassment, description of sexual harassment, examples, complaint process available, and how to contact the Commission, and there's monetary fines in Maine. Here is the Maine Human Rights poster. It says the Maine Human Rights Act prohibits sex discrimination. Sexual harassment on the job is illegal, and it provides different examples. Requests for sexual favors, which we discussed, the quid pro quo harassment, unwanted hugs, touches, kisses, lewd remarks, unwelcome sexual advances, and again, retaliation. And then it provides the Human Rights Commission's number. Connecticut is another state that actually has sexual harassment guidelines in place. We can go through those. Just a second, I have to move back here. 1 second. Here we go. Okay, so Connecticut was the second state to take steps to require employers to post notices and to conduct training at companies. So Connecticut law requires an employee having 3 or more employees to post in a prominent and accessible location information concerning the illegality of sexual harassment and the remedies available to victims of sexual harassment. In bold-faced type on this posting, it says sexual harassment is illegal. There's a link to the actual flyer in this presentation. It's www.connecticut.gov, and then it's CHRO after that, and it'll say sexual harassment flyer on the. If you can click this link, or you can Google it. A lot of these are just available just by Googling and going on to the actual state's website to find out what the requirements are. The posting notice to Connecticut employees must include a statement that sexual harassment is prohibited by the state of Connecticut's discriminatory employment practices law, that's the Connecticut law, and by Title VII. It has to have a list of remedies, language stating that those who commit sexual harassment may be subject to civil or criminal penalties, the address and phone number of the Connecticut Commission on Human Rights and Opportunities, and a statement that Connecticut law requires that a formal written complaint be filed with the Commission within 180 days of the date when harassment occurred. Here's a sample of the poster. Sexual harassment is illegal, bold-faced type, and is prohibited by the Connecticut Discrimination Employment Practices Act. I'm not going to go through the poster again. It has many of the same requirements as we've seen in other states, and you can find it on the website. For Connecticut, employers with 50 or more employees have to provide 2 hours of training and education to all supervisory employees. To supervisory employees, again, that's supervisory employees. The training must include information concerning the federal and state provisions on sexual harassment, the types of remedies available to victims, and while Connecticut initially had required that this training take place in a classroom-like setting, remember this was back in 1992, online trainings are now permitted by the state if the online training meets the state requirements and there is a method for the employees to ask questions. So again, Connecticut is now keeping up with other states, and it's important to have it as interactive, and they allow it. However, knowing that all the technology that exists now, they're permitting online training. Recently, Connecticut attempted to enact broader training requirements in its Time's Up legislation. There was a lot of articles about this in the newspaper. The legislation would have expanded Connecticut's training requirements to all employees at any Connecticut company with 20 or more employees, expanding the current training requirements. The legislation in Connecticut passed in the state Senate, but it died in the House of Representatives. So Connecticut had tried to become more proactive and expand its training requirements, but it did not pass. The legislation did not pass. So HR takeaways from the state response to MeToo. With the MeToo movement, other states, as I mentioned at the beginning of the program, there's a lot of legislation that hasn't necessarily passed at the state level, but other states should soon follow in enacting their own sexual harassment prevention laws. It's ultimately up to your company's executives, your HR departments, to take action, however, to make these laws become effective in your companies. You need to hire trained investigators, attorneys, or you as human resources personnel. You have to ensure that the company's policies are not only drafted correctly, you may have an attorney that you've consulted to draft your policies or to conduct the training, or somebody who's been trained accordingly. But it's not enough that the policies are drafted correctly. You have to have someone at the company who's responsible for implementing and enforcing the policies and the training in the workplace so that you're not going to face liability for a sexual harassment claim. Given the sensitive nature of sexual harassment investigations, trained company representatives or outside human resource companies should conduct the investigations impartially and thoroughly. Supervisors and managers also should be trained as to how to address workplace misconduct. We've discussed that. Without meaningful action, companies will continue to face liability for sexual harassment, and the policies at your company are not going to be worth the paper they're written on. I do think that it's important if you can, to have somebody who conducts whoever's conducting the investigation to have a wealth of experience in conducting investigations. It's the most important part of this process. It has to be done by somebody who has knowledge of how to handle it sensitively, who knows how to ask the right questions and to gather facts to keep it confidential. So we're going to go through some of the investigation process later in this presentation, but I think just having the right person in place will save you quite a lot in future potential lawsuits or liability. Discussion of a zero tolerance policy proposal for companies. You might have heard of this concept of zero tolerance. A company's zero tolerance policy towards sexual harassment in the workplace would require that an employee will be terminated from his or her position if the employer determines that he or she has committed any act of sexual harassment that is likely unlawful. So with a zero tolerance policy, employee supervisors who commit sexual harassment, they'll receive no warnings or disciplinary action regarding the unlawful behavior. They don't benefit from warnings, nor do they have the right to a probationary period. With a zero tolerance policy, even one act of sexual harassment could lead to immediate termination. Again, this is a topic that a lot of employment lawyers are discussing and companies are interested in discussing. New York State did not include a zero tolerance policy in its final sexual harassment guidelines, even though earlier drafts of the guidelines did include a requirement for zero tolerance policy. In fact, I remember reading the guidelines when they came out. I think it was a draft of them, maybe even in late summer or early fall, when there was, I believe, a zero tolerance policy included in there. So the New York State has actually received a lot of comments about zero tolerance policy from companies, from attorneys, and they decided to go against the wording that you're required to have a zero tolerance policy at your company. This coincides with the Equal Employment Opportunity, the EEO's guidance against using the term. A 2016 task force of the EEO discovered that the phrase could lead to an underreporting of sexual harassment if an employee believes that someone will be terminated over a complaint regardless of the severity. The EEO suggests using a statement such as absolutely no harassment will be permitted in the workplace, but refraining from specifically calling it a zero tolerance policy. So I think it's important if you have an interest in what a zero tolerance policy is and whether it's worthwhile to perhaps look at the study that the EEO did on zero tolerance. I think part of the issue that many are concerned is that just terminate. What if you have a 30, 40-year employee who makes a mistake and says an off-color joke or makes a sexual reference or leers at somebody inappropriately or something, and it's a one-time occurrence, it's a mistake under the zero tolerance policy, that executive would have to be terminated. So many companies are concerned about that, and it's just something to consider. Here we're going to talk about supervisor responsibilities and the internal-external complaint process. We've alluded to that, but we're going to get into the specifics of it now. So steps to filing an internal company complaint. I'm sure many of you have dealt with situations where, hopefully you haven't, but I'm sure many of you have dealt with a situation where an employee has come to you with a sexual harassment complaint. Here's what I think should be done, and hopefully your company is doing this. Companies should first advise employees to inform or put the harasser on notice that his or her conduct is unwelcome and unwarranted. So if an employee is being approached by a supervisor who's acting inappropriately, they have to say to the supervisor, and it takes a lot of courage to do this, and it may not always be possible if an employee feels vulnerable, but they should, if they can, put the harasser on notice. You should let them know that they should put the harasser on notice that the conduct is unwelcome and it's unwanted, and that's important, so that the harasser is set straight immediately that this type of conduct is unwelcome. The employees, if they feel empowered to be able to do this, they don't fear retaliation. If you're an open company with these types of situations, the employee should not fear doing this. It's an important step. You should also inform all of your employees that they should immediately report, not wait, immediately report an incident or incidents to a supervisor and fill out a written complaint form. You've seen the complaint form that the New York State sets forth. It was provided earlier in this program. The internal complaint should specify the dates, times, witnesses, parties involved, and the details of the incident, and the company should have designated personnel, such as the Human Resources Department, where the incident should be reported. So employees shouldn't be wandering around wondering, oh, where do I go to report this incident? Have somebody identified. Have the Human Resources Department identified so that an employee knows where to go in a somewhat distressing situation. The company should then complete a thorough investigation of the complaint. It doesn't matter how trivial they think it is at this present time, and any time really. The company should take immediate action once an investigation to conduct the investigation, and once it's complete, they should appropriately sanction any wrongdoer. A company should also explain the process. A lot of clients will say, "I don't know if they investigated or what they did. I don't know the process they took." This is a very real concern for plaintiffs that I have met with about the company handling a complaint of sexual harassment. If they don't understand the process, if you don't keep the employee up to date, it can cause more stress, potentially more damages to the employee, and that all goes into an employee deciding whether or not to sue a company. So explain the process. We'll be conducting this investigation. Here's the different types of information they need to provide. Go through the complaint form with them and explain the process. Review the company's harassment guidelines. And the fact that all employees of the company should have read and signed the guidelines and provide specific information to the employee regarding the steps to be taken regarding the complaint and what's going to happen in the investigation. Again, I touched on this before. Investigations should be handled by company personnel that are experienced in conducting sensitive investigations. Fact-finding should occur with the investigator, making it clear that any information will be kept confidential, and the parties directly involved in the investigation are the only persons that they will discuss the investigation with. The fact finder, the investigator, should listen to both sides and remain impartial. Even though they're technically representing the company, they need to remain impartial when they interview the plaintiff and when they interview the supervisor. So all witnesses to any incident should be interviewed, and at the conclusion of the investigation, both parties should be informed of the findings, the determination of the findings, and any disciplinary measures taken by the company. I can't tell you how many clients have come to me and told me they have no idea what happened. I mentioned this before regarding any sort of sanction against the harasser. It's problematic. It leaves victims vulnerable. It's an important step that your company needs to take. Steps to filing an internal company complaint. Companies should take the lead in requiring supervisors and managers. You have to have a good training process in place for supervisors and managers to regulate, report, and remain above any harassment at the company. A lot of times, unfortunately, from what I've seen, some of the supervisors and managers are actually, if not participating in the harassment, are aware of it. So there has to be a very good program to advise supervisors and managers, and the HR department needs to be independent. A lot of times HR departments are connected, very connected to executives. So you have to have an independent, a somewhat independent human resources department who can actually take the lead and train supervisors and managers, even people above them, about how to conduct themselves in the workplace. As a supervisor, the company must require that they report any allegation and promulgate the company's sexual harassment guidelines, that they have to be aware and responsive to any harassment that may be occurring, that they need to thoroughly investigate any complaints, and to act preventatively by setting high standards for employees and leading as a role model of proper conduct. To the extent the company becomes aware that supervisors or managers are engaging in sexual harassment, they should be disciplined and immediately removed if warranted. I see that we're getting close on time, so I am going to just quickly go through the rest of this. There's a lot left. Just regarding investigation and corrective action, companies should advise anyone who engages in sexual harassment or retaliation that they may be subject to remedial action. Employers must investigate. The investigation process may vary from case to case, so you need a trained investigator. It should be completed as soon as possible. And any employee that's required to cooperate needs to know they won't be retaliated against. I'm going to skip some of the specifics of the investigation process. It just really deals with common sense things, that the relevant documents and emails should be preserved and obtained, interviews should be conducted, and an investigation should be documented. That's important. Document the investigation and outline how you're going to do it, the investigation in your sexual harassment policy. These additional measures are just the state and federal laws. The state laws, the New York State Division of Human Rights. A complaint alleging violation of the human rights law can be filed with the Department of Human Rights, or you can go directly to New York State Court. You can read about the requirements of the statute of limitations. Complaints filed with the Department of Human Rights are anytime within 1 year. And you can also, as I said, sue directly in state court. The EEO complaint in New York, it's 300 days. You do not need an attorney to file a charge of discrimination, although it's advisable, and it must be filed. A charge of discrimination must be filed with the EEOC before you file, before you can bring a case in federal court. Local protections. Many localities enforce laws protecting individuals from sexual harassment and discrimination. As an employee, if you've been assaulted, I've had clients who've done this, you can even contact the local police department. Your employee can contact the local police department. In fact, many times companies may be obligated to do that if there's been a sexual assault. I'm not going to go through the supervisor's responsibilities. We have touched on that already. One hypothetical I was going to discuss, but I'll just go through quickly, is when you actually are concerned regarding the public relations impact of MeToo as a company, and you need to make sure there's no high-profile scandals at your company. One suggestion to prevent any sort of issues is increasing due diligence in your hiring practices, such as background checks that might reveal past harassing conduct. Just make sure that you treat everyone equally in the background checks and that there's no discriminatory background checks issues. Prevention is key. We've talked about this. The best method to eliminate sexual harassment is to be proactive and take the necessary steps to prevent sexual harassment from occurring. I'm going to go through these quickly because I know that we're running out of time. The federal law, Title VII, and the local New York City law, 15 or more employees. New York State law, again, in general, the New York State human rights law occurs to employers with 4 or more employees, but it's been amended in terms of sexual harassment to apply to companies, to all employers, regardless of the number, as long as there's 1 employee. The next section really talks about who handles investigations. So the EEOC does prosecute claims of discrimination. So does the New York State Human Rights Department. And employees or independent contractors, vendors of a company, they can go outside of an internal complaint process and file a charge of discrimination with the EEOC, and that will set forth all of the facts that form the basis for the complaint of harassment. This federal and state sexual harassment regulations, agencies will investigate. If an agency investigates and determines the law has been violated, the EEOC may also try to reach out and mediate. They have the right to do that. If the EEOC does not take the case itself, well, the EEOC very rarely takes cases. If they do not file a lawsuit, they will give the employee or former employee of your company a notice of right to sue, which gives them the right to go to federal court. And this next slide deals with federal remedies for sexual harassment. Again, Title VII, and it discusses some of there are caps on recovery under federal law. I'm not going to go over that, but there are caps. There's certain things you're entitled to in terms of damages at the federal level, and at the state level, there's differences, so you should know that. Title VII, as I said, does not allow an employee of yours to go immediately to court to file a lawsuit. They have to exhaust the administrative remedies. They have to file the charge of discrimination. If the EEOC has not resolved the employee's case within 6 months, the employee can request the right to sue and go to federal court. In New York, in some states, it's 180 days. In New York, it's 300 calendar days to file a charge of discrimination, because we have a state or local law that prohibits employment discrimination on the same basis as Title VII. And if there's multiple acts of harassment, this is important, or ongoing harassment, victims are still required to file their charge within 300 days of the last incident of harassment in New York, but the EEOC will look at all incidents of harassment when investigating the employee's charge, even if the incidents happen prior to the 300 days. New York State law, there's a different types of damages. It talks about attorney's fees, lost wages, emotional distress. Again, the damages in New York are different. You should be aware of both guidelines in federal and state law. Again, I talked about the fact that there's no requirement under the New York human rights law to file an administrative claim before proceeding with a lawsuit. And then the damages again. Trends in MeToo litigation, this is the end of the program. Just so you know, and so you can protect your company, it's an important issue. Sexual harassment, especially with the whole MeToo viral movement and state action. There's been an increase in the total number of filings in fiscal year 2018, according to the EEOC. The recent study just shows an uptick in the number of actions and lawsuits. There's other types of lawsuits that can be brought that you can be vulnerable to. There's litigation at the state and federal level. There's defamation claims, and there's securities class actions and shareholder derivative actions. You can look at the CBS example and the Bill O'Reilly matter regarding securities class actions and shareholder derivative actions, and that's important to keep in mind as well. So the trends, as a summary, the trends in litigation as a result of the MeToo movement make it even more important for HR to have a strong controls in place and to thoroughly, efficiently investigate and act on allegations. HR departments should seek legal advice. A lot of companies have come to me and said, "Look, they don't even. Some of these smaller companies don't have HR departments, or they haven't become aware of the guidelines that are required to be put into place in their company. It's important to seek legal advice concerning a determination of what you need at your company in the handbook and policies, and also legal advice concerning a determination of when allegations of misconduct or findings of an internal investigation, how they should be disclosed in the organization, any statements that might need to be made, and also in considering severance or settlement payments. I'm sure you probably do this already, but it's also important to consult an attorney." Let me go to... Okay. Hi. I have a couple.
Yeah, so we have this question.
Okay, just one? Okay. All right. So the question is, are there any other requirements for New York City employees training other than the poster requirements? Yes, there's also a training requirement for New York City. New York City companies also have to train their employees just as you do in New York State. So the answer to that is yes. I think that's it. It's 2 o'clock. So.
Okay. Well, on behalf of Siri Trey, we'd love to say thank you.
Oh, thank you. Oh, that's so nice. Thank you.
Siri Trey.
Thank you.
Everyone enjoyed the presentation, and don't forget to sign up for some of the other great programs we have. Yeah. Everyone, if you do have questions, as a follow-up, you can reach out to Kathryn directly or reach out to the Siri Trey office. We did record the presentation today, so we'll be posting it on the website. So if there's anything that you missed or wanted to hear again, you'll just be able to look out for that announcement. So thanks, everybody, and have a great rest of your day.
Thank you.